Anisha, if I could briefly go back to Dayan Krishnan's argument, Manish Sisodia's counsel, they say that they had to first, the ED has to first show proceeds of crime. So when it boils down to that, show us proceeds of crime, what does that really mean? Basically, counsel asking what proof does the ED have that this is a money laundering case? Show us proceeds of crime. But you earlier yourself said that it's not necessary for any proceeds or money to have been received while the ED investigates the matter. So what do you think the court, how do you think the court will observe this?
See, Nabila, what I meant when I said that no specific transaction of money, what I'm saying is that there is no need for a specific evidence that I personally took this money from X person. However, what Sisodia's lawyers are saying that there is no money trail whatsoever that has been found by the ED, that not a penny has been traced to me, and that is why now the ED is arguing, and I'm reading out this argument that was sent by Srishti, that not a penny has been traced to me. That is why now they say Vijay Nair is acting on behalf of Manish Sisodia, and this is laughable. That the file was sent to the LG, all the documentation, all the passing of the policy was done as per procedure, and there is no evidence of money being received by any person, by Manish Sisodia particularly. That is what Sisodia's lawyers are now arguing. What the law specifically says is, and as I've been repeating again and again, the law does not require Manish Sisodia to have directly received 100 crore rupees from any person. The law requires the ED to have traced that X amount of money was received, and these are the people through whom the money flow went, and these are the people who facilitated that flow of money. Now, Sisodia's lawyers are questioning, how do you prove that? Where is the proof of that? How exactly is the ED saying that there was any flow of money whatsoever? So further arguments and further investigation when it comes out, if the ED is able to show that there was these transactions, because the ED, remember, has said that there were meetings between Vijay Nair and K. Kavita. The ED has said that there was money that was transferred from Hyderabad to Delhi. Now, if the ED can show that whatever money transfers that they're talking about was linked to these the liquor policy changes, then it will be game over for Mr. Manish Sisodia. But of course, at this stage of the investigation and at this stage of the process, Nabila, no one can really give you a very clear answer to who has the money, what money, where is the money gone. The ED is saying that they have received, they have investigated into transactions, that ED is saying that there was transfer of funds from Hyderabad to Delhi, and that fund transaction was in fact, according to the ED, facilitated by the quick grant of L1 licenses to the South Cartel members. However, on the other hand, of course, we have this Sisodia's counsel saying you have no evidence that any money changed hands, and simply because a policy went through very quickly does not mean that there was any sort of corruption involved. In fact, a very interesting line of argument now being raised by Mr. Mohit Mathur, that GST is also another fiscal policy, and the applicability of Section 167 of the CRPC with regard to investigation, all of those are now being questioned by the senior counsel, who is saying that just because a policy has been passed, you cannot claim that this policy has been passed in a corrupt manner. You cannot simply raise an allegation that some witness has said that they saw or they heard somebody taking a decision. That what the Sisodia's lawyers are banking on effectively is what the ED has also been saying, that there has been destruction of evidence, that their phones were destroyed, SIM cards were changed, etc. And that file notings, and this is something that the CBI had also said earlier, remember, that file notings have gone missing. The Sisodia's lawyers are saying that when the file says that it has gone through the entire process, when the file shows that public opinion was taken, when the file shows that the GOM has passed these directions, when the file shows that the LG was also consulted, and that is where the crux of their argument has been, that when the LG himself has passed the file and only raised some other concerns, the LG never raised a red flag when it came to this 12% profit margin or L1 licenses, then how can the agencies now say that the policy that was duly passed from every department, from every level, from every layer, and even through the LG and the central government, how can that now be questioned? So we'll have to wait and see how the court really analyzes all of these arguments, because this is not a very simple case, Nabila. This is a very, very complicated case where a lot of questions have been raised and will continue to be raised about how laws are passed in this country, how policies are drafted, what kind of back-end negotiation goes into the picture when policies are being created. Can you really say that simply because a political leader of one party met the political leader of a different party, therefore there had to be some sort of a monetary transaction? How exactly will you relate political alliances or political allegiances with the financial transactions or policy changes to benefit a particular person? All of these are very complicated questions that are being raised in this particular case, and as we speak, the arguments are still ongoing, and my colleagues Kanu Sharda and Srishti Ojha are inside.
Right.